We back. Federal Reserve Act. I don't know which section we on, but this is 3 where we left off. Branches of state member banks. Any such state bank which at the date of the approval of this act has established and is operating a branch or branches in conformity with the state law may retain and operate the same while remaining or upon becoming a stockholder of such Federal Reserve Bank, but no such state bank may retain or acquire stock in a Federal Reserve Bank except upon relinquishment of any branch or branches established after the date of the approval of this act beyond the limits of the city, town, or village in which the parent bank is situated, provided, however, that nothing herein contained shall prevent any state member bank from establishing and operating branches in the United States or any dependency or insular possession thereof, or in any foreign country on the same terms and conditions and subject to the same limitations and restrictions as are applicable to the establishment of branches by national banks, except that the approval of the Board of Governors of the Federal Reserve System instead of the Comptroller of the Currency shall be obtained before any state member bank may hereafter establish any branch, and before any state bank hereafter admit to membership may retain any branch established after February 25th, 1927, beyond the limits of the city, town, or village in which the parent bank is situated. The approval of the bank shall likewise be obtained before any state member bank may establish any new branch within the limits of any such city, town, or village. 12 U.S.C. 321. 4. Financial condition, management, and powers. In acting upon such application, the Board of Governors of the Federal Reserve System shall consider the financial condition of the applying bank, the general character of its management, and whether or not the corporate powers exercised are consistent with the purposes of this act. 12 United States Code 322. 5. Payment of subscription. Whenever the Board of Governors of the Federal Reserve System shall permit the applying bank to become a stockholder in the Federal Reserve Bank of the district, its stock subscription shall be payable on call of the Board of Governors of the Federal Reserve System, and stock issued to it shall be held subject to the provisions of this Act. 12 U.S.C. 323. 6. Provisions of law to be complied with. Reports of conditions. All banks admitted to membership under authority of this section shall be required to comply with the reserve or capital requirements of this act, to conform to those provisions of law imposed on national banks which prohibit such banks from lending on or purchasing their own stock, and which relate to the withdrawal or impairment of their capital stock, and to conform to the provisions of sections 5199B and 5204 of the revised statutes with respect to the payment of dividends, except that all reference in any such provision of the comptroller of currencies shall be deemed for the purposes of this sentence to be a reference to the Board of Governors of the Federal Reserve System. Such banks and the officers, agents, and employees thereof shall also be subject to the provisions of and to the penalties prescribed by sections 334, 656, and 1005 of Title 18 United States Code, and shall be required to make reports of condition and of the payment of dividends to the Federal Reserve Bank of which they become a member, not less than 3 years, not less than three reserve banks, not less than three reserve banks of which they become a member, not less than three of such reports shall be made annually on call of the Federal Reserve Bank on dates to be fixed by the Board of Governors of the Federal Reserve System. Any bank which maintains procedures reasonably adapted to avoid any advertent error and unintentionally, and as a result of such an error fails to make or publish any report required under this paragraph, within a period of time specified by the board, or submits or publishes any false or misleading report or information, or B, inadvertently transmits or publishes any report which is minimally late, shall be subject to a penalty of not more than $2,000 for each day during which such failure continues, or such false or misleading information is not corrected. The bank shall have the burden of proving that an error was inadvertent and that a report was inadvertently transmitted or published late. Any bank which fails to make or publish such reports within the period of time specified by the board, or submits or publishes any false or misleading report or information in a manner not prescribed in the second proceeding sentence, shall be subject to the penalty of not more than $20,000 for each day during which such failure continues, or such false or misleading information is not corrected. Damn. Notwithstanding the preceding sentence, if any bank knowingly or with reckless disregard for the accuracy of any information or report described in such sentence, submits or publishes any false or misleading report or information, the board may assess the penalty of not more than $1 million or 1% of the total assets of such bank, whichever is less, per day for each day during which such failure continues, or such false or misleading information is not corrected, in a penalty imposed under any of the four preceding sentences shall be assessed and collected by the board in the manner provided in subparagraph E F, G, and I of Section 8 I-2 of the Federal Deposit Insurance Act for penalties imposed under such section and any such assessment, including the determination of the amount of the penalty, shall be subject to the provisions of such section. Any bank against which any penalty is assessed under this subsection shall be afforded an agency hearing if such bank submits a request for such hearing within 20 days after the assurance of the notice of assessment. Section 8H of the Federal Deposit Insurance Act shall apply to any proceeding under this paragraph. Such reports of conditions shall be in such form and shall contain such information as the Board of Governors of the Federal Reserve System may require. 12 U.S.C. 324. 7. Examinations. As a condition of membership, such banks shall likewise be subject to examinations made by direction of the Board of Governors of the Federal Reserve System or of the Federal Reserve Bank by examiners selected or approved by the Board of Governors of the Federal Reserve System. 12 U.S.C. 325. Acceptance of state examination, expenses, reports of examination. Whenever the directors of the Federal Reserve Bank shall approve the examination made by the state authorities, such examinations and the reports thereof may be accepted in lieu of examinations made by examiners selected or approved by the Board of Governors of the Federal Reserve System, provided, however, that when it deems it necessary, the board may order special examinations by examiners of its own section of selection, and shall in all cases approve the form of the report. The expenses of all examinations other than those made by state authorities may, in the discretion of the Board of Governors of the Federal Reserve System, be assessed against the bank examined, and when so assessed, shall be paid by the banks examined. The Board of Governors of the Federal Reserve System, at its discretion, may furnish any report of examination or other confidential supervisory information concerning any state member bank or other entity examined under any other authority of the board, or any federal or state agency or authority with supervisory or regulatory authority over the examined entity, and to any other person that the board determines to be proper. That's 12 U.S.C. 326. 9. Forfeiture of membership. Forfeiture of membership. If at any time it shall appear to the Board of Governors of the Federal Reserve System that a member bank has failed to comply with the provisions of this section or the regulations of the Board of Governors of the Federal Reserve System made pursuant thereto, or has ceased to exercise banking functions without a receiver or liquidating agent having been appointed. Therefore, it shall be within the power of the board, after hearing, to require such bank to surrender its stock in the Federal Reserve Bank and to forfeit all rights and privileges of membership. All rights and privileges of membership. The Board of Governors of the Federal Reserve System may restore membership upon due proof of compliance with the conditions imposed by this section. 12 United States Code 327. 10. Voluntary withdrawal from membership. Any state bank or trust company designed to withdraw from membership in the Federal Reserve Bank may do so after 6 months. Written notice shall have been filed with the Board of Governors of written notice shall have been filed with the Board of Governors of the Federal Reserve System upon the surrender and cancellation of all of the holdings of capital stock in the Federal Reserve Bank, provided that the Board of Governors of the Federal Reserve System, in its discretion and subject to such conditions as it may prescribe, may waive such 6 months notice in individual cases, and may permit any such state bank or trust company to withdraw from membership in a Federal Reserve Bank prior to the expiration of 6 months from the date of the written notice of its intention to withdraw, provided, however, that no Federal Reserve Bank shall, except under express authority of the Board of Governors of the Federal Reserve System, cancel within the same calendar year more than 25% of its capital stock for the purpose of effecting voluntary withdrawals during that year. All such applications shall be dealt with in the order in which they are filed with the board. Whenever a member bank shall surrender its stock holdings in the Federal Reserve Bank, or shall be ordered to do so by the Board of Governors of the Federal Reserve System under authority of law, all of its rights and privileges as a member bank shall thereupon cease and determine, and after due provision has been made for any indebtedness due or to become due to the Federal Reserve Bank, it shall be entitled to refund of its cash paid subscription with interest at the rate of 0.5% per month after date of last dividend, if earned. The amount refunded in no event to exceed the book value of the stock at that time, and shall likewise be entitled to repayment of deposits and of any other balance due from the Federal Reserve Bank. 12 U.S.C. 328. I'm going to read this whole thing over. Voluntary withdrawal from membership. I'll be back at man. No applying bank shall admit to membership unless it possesses capital stock. No applying bank shall be admitted to membership unless it possesses capital stock and surplus, which, in the judgment of the Board of Governors of the Federal Reserve System, are acquired in relationship to the character and condition of its assets and to its existing and prospective deposit liability and other corporate responsibilities, provided that no bank encouraged in the business of receiving deposits other than trust fund, which does not possess capital stock or surplus in an amount equal to that which would be required for the establishment of all national banks associated in the place in which it is located, shall be admitted to membership unless it is or has been approved for deposit insurance under the Federal Deposit Insurance Act. The capital stock of a state member bank shall not be reduced except with the prior consent of the board. 12 U.S.C. 329. Waiver of membership requirements as to insured banks. In order to facilitate the admission of membership in the Federal Reserve System of any state bank, which is required under subsection Y of section 12B4 of this act, to become a member of the Federal Reserve System in order to be an insured bank or continue to have any part of its deposits insured under such section 12B. The Board of Governors of the Federal Reserve System may waive in whole or in part the requirements of this section relating to the admission of such bank to membership, provided that if such bank is admitted with a capital less than that required for the organization of a national bank in the same place, and its capital and surplus are not, in the judgment of the Board of Governors of the Federal Reserve System, adequate in relation to its liabilities to depositors and other creditors, the said board may, in its discretion, require such bank to increase its capital and surplus to such amount as the board may deem necessary within such period prescribed by the board, as in its judgment shall be reasonable in view of all the circumstances, provided, however, that no such bank shall be required to increase its capital to an amount in excess of that required for the organization of a national bank in the same order, in the same place, omitted from United States Code. This is 12 laws to which subject. Laws to which subject. Banks becoming members of the Federal Reserve System under authority of this section shall be subject to the provisions of this section and to those of this act which relate specifically to member banks, but shall not be subject to the examination under the provisions of the first two paragraphs of Section 5240 of the revised statutes as mentioned by Section 21 of this Act, subject to the provisions of this Act and to the regulations of the board made pursuant thereto. Any bank becoming a member of the Federal Reserve System shall retain its full character and statutory rights as a state bank or trust company, and may continue to exercise all corporate powers granted it by the state in which it was created, and shall be entitled to all privileges of member banks, except that the Board of Governors of the Federal Reserve System may limit the activities of bank member banks, state member banks, and subsidiaries of state member banks in a manner consistent with Section 24 of the Federal Deposit Insurance Act. Deposit Insurance Act. No Federal Reserve Bank shall be permitted to discount shall be permitted to discount for any state bank or trust company notes, drafts, or bills of exchange of any one borrower who is liable for borrowing money to such bank, state bank, or trust company in an amount greater than that which could be borrowed lawfully from such state bank or trust company where it is nationally banking association. The Federal Reserve Bank, as a condition of the discount of notes, drafts, and bills of exchange for such state bank or company or trust company, shall require a certificate or guarantee to become liable provided by this section, and will not be permitted to become liable in excess of this amount while such notes, bills, drafts, bills of exchange, or under discount with the Federal Reserve Bank under 12 USC 330. We're going to kill it there. 14, false certification of check. False certification of checks.